Folks, we just listened to a sentencing hearing in the Anissa Weier case out of Wisconsin. This is the so-called Slenderman case. It's a young defendant who basically admitted to the underlying charge, but said that there was a mental issue that needed to be sorted out by the court. What ultimately happened was what we could call a mini trial that was flipped around, because in Wisconsin, when the defendant raises a mental health issue, it's the defendant's burden to prove that that mental health issue exists, and then the state gets a chance to rebut it. The jury in that sort of flipped mini trial ultimately concluded that a mental health issue existed, so the question was how long the commitment to a mental health facility should be. Brian Wagner is a local criminal defense attorney here in New York City. He's joining us on the Law&Crime Network. Brian, we just watched this. We concluded that it probably was the longest sentencing hearing that either of us have heard combined. So you add yours up, I'll add mine up, and it would still be about half the length of time we just saw.
Good afternoon. Thanks for having me. It was absolutely very long, but when you just boil down to what the judge was saying, what he was saying was essentially that no matter how much she has improved since the date of the crime, she's always going to pose a danger to society in terms of Wisconsin and possibly herself, and for that reason, the longest statutory allowed time of confinement is what the judge elected to do.
So we've got 25 years here. Ultimately, that's what the state asked for. The state got its request, got its wish, lock, stock, and barrel all the way across the board. And the judge did say the release would pose a significant harm to yourself or to others. That was the key language that was buried in a lot of what was said there. And a 25-year commitment. Of course, there's the chance of an appeal. The court can monitor and, in fact, compel any medications that may be prescribed. But it seems like the judge didn't buy anything that the defendant was saying to sort of make amends for or apologize for the crime. And you were a little bit surprised at how far she went in apologizing.
Well, I think what happened was the state gave a compelling reason why the maximum statutory time should be allowed. And the judge kind of pointed that out. What he said is, even though I'm sentencing 25 years, that doesn't mean you're going to actually be confined 25 years. Because the institution is able to say, we're going to grant you conditional release, and we think you're going to be not a danger to society. But if he had sentenced, let's say, 10 years or 15 years, then the institution is bound by that. So by giving a longer statutory time, it really puts the decision in the hands of the mental health professionals that will make the determination. In terms of the defendant's own statement, I am surprised because I've done enough trials where I usually do not hear a defendant get up and say, I'm taking responsibility. I'm sorry for what I did. But in the end, although she's mentally healthy today, the judge's fear is that she might not be mentally healthy tomorrow.
Yes, that seemed to be the fear. And of course, we heard some discussion there about travel restrictions were she to be released from the facility and things like that. That's not a surprise in a case like this.
Definitely not. That's pretty standard, that if we're going to allow you to enter society again, we want to make sure that we're able to locate you and do our own due diligence in making sure that you're available and healthy and fit to be in society.
A couple things about the defendant's statement. I would agree that it at least at first blush, seemed heartfelt. She seems to grasp that something grave did indeed happen, but some of the language, I don't know if it was deliberate or if it was sort of a young stumbling. She said, I want to hold myself, or I'll be holding myself somewhat accountable, responsible. And it's like, no somewhat should be attached to this here. That bothered me, but maybe I'm nitpicking what may have just been sort of a stumbling slip of the tongue. And look, I mean, she's very, very young. Maybe that's just the way teenagers couch their words in Wisconsin in this day and age. But that bugged me, that one word.
And I agree with you. I think you didn't see her reading off a piece of paper. This was a speech that she was giving. Maybe she had wrote it and practiced it, but this was a speech that she was giving that was kind of fluid. And I would agree with you, saying somewhat, it's really not what you want to hear as the judge or as the prosecutor, but the main sentiment is what, as a defense attorney, I'd be latching on to, that she is taking responsibility.
Yeah, she also kept referring to what happened as a this, I want to let everyone know who is involved with this. It's an incident. It's sort of detached. I mean, look, you've got 19 stab wounds to a very young girl who was a friend.
Yeah, and there certainly is some type of disassociation that the defendant is doing. But as the defense attorney, I mean, I would keep on going back to, she is taking responsibility. She is not a public speaker in her job. She's really just a kid who's trying to take responsibility for a absolutely heinous, terrible act that she committed.
Yes. Now, is this a case where the punishment fits the crime? We've got a lot of discussions in society, and we had another one here earlier, that is Amy Dash and myself, one of my other hosts. We're battling back and forth a little bit about the status of mental health examinations in criminal law. And, when it comes to either science and law or technology in law, sometimes there's a breakdown. Some people might be sitting there watching this, saying, hey, look, this should be a drastically harsher punishment. They might not be comfortable with it.
Yeah, and I don't know how each person is going to come down on it. Me personally, what I would say is that every person is different, and every judge sentences that person differently. What you did hear from this judge was certainly a case-by-case, fact-by-fact analysis. And I think that's why his sentencing was so long, because he really wanted to make both sides understand that he's not just doing this by the book. He's looking at this case, the individual facts of this case, what the defendant has admitted to, what the mental health professionals have decided, and then what the state thinks is in the best interest of the state's population. And then he makes his decision.
And keep in mind, this decision as to mental health treatment versus prison was not a judicial decision. This was a jury decision.
Yes.
A jury sat and listened to the defendant basically try to argue that this should be my punishment, and listen to the state try to rebut it. And the jury came down on the side of the defendant. Now, part of me thinks that if this was an older defendant, the jury would not have done that. But a lot of times juries might want to look and say, hey, look, is this a teenager who was just off her rockers in some kind of alternate universe? Whereas if it were an adult, we would throw the book down and say, you can't do this. Because ultimately what it does is it now gives a teenager a long time to not only self-reflect, but to reflect with professional care. Yeah. And at the end of it, she may be a changed person. In other words, the jury was willing to give this teenager a chance to grow up, I guess, or at least be treated.
And I think in criminal law in general, we're seeing a shift towards more mental health treatment. And just in general, it takes almost every single client I've had, or when I was a prosecutor, the defendants I had, there was some sort of mental imbalance there. Use a burglary case. It takes a special kind of mind to have the chutzpah, to use a word that I'm familiar with, to have the chutzpah to go inside someone's house while they're asleep. That takes a mental ability to shoot someone at point blank. That takes a mental ability that most people in society don't understand. So there's always a mental health issue in the framework. It just, as society, what are we willing to tolerate? And I think what this jury said was, this is clearly someone that was disturbed, so disturbed that she was having mental hallucinations. She needs and requires some type of mental health. And that's what they decided to do.
Yeah, we're also keeping an eye out for a possible verdict. We're not sure how long they'll deliberate, so I say possible verdict in the Whaley case out of Iowa. It's a case we've been following for a couple of days this week. Short trial the main where defendants keep basically opening fire at about 3 o'clock, 3:30 in the morning in Mason City, Iowa, and striking and killing someone who was on the other side of the door. Now, she had a key. She had been over to his place earlier. She was coming back to retrieve a bicycle, apparently. He thought that it was really a former roommate who also had a key, who apparently, we've been back and forth on this one as well, too. I think it's a relatively slam dunk conviction, and I'm looking at it through the lens that it's just not reasonable. That in Iowa, when you try to cop a defense of self-defense, it's that objective reasonableness standard. And of course, what that means is, does society look at this and say, what he did makes sense?
Yeah.
I don't think it makes sense to me. I don't think it makes sense to open fire through a closed door before knowing what's really going on the other side of it, especially after you've just given a key to someone who might be potentially coming back.
Yeah. So just as an aside, this is also, that defendant has some mental health issues as well, and he was determined to be competent to stand trial. So going back to what I was saying, there's always some sort of mental health issue when you have these really violent crimes, almost always. Now, in terms of the reasonable standard, across the country, the self-defense standard is almost always a reasonable standard. What would an ordinary person believe? In New York and other states, there's also a subjective standard. What did this defendant actually believe? Iowa doesn't require that. In terms of whether or not it's reasonable, that's a question of fact for the jury, and they'll decide whether or not it is. But things that they will consider are the misdemeanor, whether or not she was being stalked by an ex-boyfriend or an ex-roommate, and did that play into the defendant's reasonableness in believing that someone was breaking in. The defendants also had other interactions with other people where he believed they might be breaking into his house. So it's not just a reasonable person, it's a reasonable person in this defendant's exact circumstances. And really that's a question of fact that the jury is going to have to grapple with. And it's a difficult one because convicting someone beyond a reasonable doubt, it's not just probably did it and probably was not justified, it's beyond a reasonable doubt was not justified.
Yeah, well, this jury has been deliberating for a couple of hours now, and they're trying to sort it all out as we speak. We're not sure how late they're going to go tonight. If we get a sense of when the cutoff time is for deliberations, we'll let you know. And of course, if there's a verdict, we'll go straight back to the courtroom. In the meantime, let's listen to some of the defense's closing arguments in this case. These happened earlier this afternoon. It's the first time I'll be getting a chance to listen to them. Let's listen to them now.
What you've had to witness this last week, words defy the ugliness and the tragic nature of what you've had to listen to. You truly are a credit to your service for doing what you have done, and I thank you. This part of the case is probably my least favorite part of the case. Because I represent a gentleman sitting over there, Larry Whaley, and this is my last time to talk to you. I have to make sure that I tell you everything that's important about this case. I have to tell you what I think is important, and I have to rebut what Mr. Hammerhand has told you all at the same time. So I have two notebooks. When I sit down, Mr. Hammerhand is going to stand up, and he's going to tell you, no doubt, about things that I missed, that I didn't talk about. And that's why I hate this part of the case, because I'll be sitting over there wanting to jump to my feet and respond. That's not the way our system's set up. So, let me just say this to you. I ask for your forgiveness if I speak a little bit longer than what you're able to tolerate, if I spend a little bit more time than what you think I need to spend, or if I go over things and repeat myself. I also ask you that when I sit down, that you continue to look at the evidence critically and to use your common sense. Because that's kind of my job too. Look at the evidence critically, use my common sense, and tell you my client's case, his story. So I ask that of you. On December 1st, 2016, Deborah Ewing had some sort of, I don't know what you'd call it, an incident with Jason Bendixson. Jason had a cut hand, there was some kind of problem with an old girlfriend or a mother of a child or something. She put him to bed and she said, when you get up, I'll make you chili. Problem is, when he got up, she wasn't there. She was with Larry Whaley, and they were running around doing whatever. Mr. Bendixson, by all accounts, went ballistic. He freaked out. This became known to Ms. Ewing and to Mr. Whaley. They were scared of Mr. Bendixson. You know, that's just one thing that Mr. Hamran didn't tell you. On the same day, police officers came to Mr. Whaley's home and woke up Corey Mays off the couch and very unceremoniously said, "Out. You're out." The officers that you heard from today described Mr. Mays as being upset. Every police officer that I asked confirmed that Mr. Mays is known to carry a gun. And how do we know this? Because the police officers put it in their system for every other police officer in the world that happens to check out Mr. Mays on the computer. There's an alert. He is known to carry a gun. Why did they do that? Because when they stop a car that has Mr. Mays in it, they don't want to get killed by a gun that they had no clue about. Now, they don't just do that for Mr. Mays. They do it for other people as well. But it's a serious thing. It's not just, we don't like him, let's put this in our nationwide computer system. What else did they tell you? Investigator Prochaska. That Mr. Mays, first of all, there was a shooting last October at a mall. And it started something about in a bar, and Mr. Mays was in that bar. Larry Whaley knew about that event because he lives here in Mason City, and he knew Mays. And Larry Whaley believed that Mr. Mays was involved in that shooting. And Mr. Whaley believed that Mr. Mays carried a gun. Police officers had in their computer a warning that he might. Mr. Whaley believed that he did. And the day that Mr. Mays was asked to leave the apartment, Mr. Whaley told the police he's got a gun in there. He even let the police come in and look for the gun, and they didn't find it. What else did those police officers say today? Mr. Whaley gave Mr. Mays a key. The officer didn't know which door it was to, but he knew it was so Mr. Mays could get back in and get a box of property that he didn't have room for. So what does Mr. Whaley know on the morning of December 1st? Or let's say the evening of December 1st at 9 o'clock at night, 7 o'clock at night. Bendixson's mad at him. Bendixson is freaking out, looking for Deb Ewing. Deb Ewing is with Mr. Whaley. Who knows what Mr. Bendixson is capable of? More importantly, Mr. Mays, known to carry a gun by Mr. Whaley and confirmed by the police, has been ejected from Mr. Whaley's house and is upset. Same Mr. Mays that was involved, according to Larry, in this mall shooting, who has a key to Mr. Whaley's house because Mr. Whaley...
We are reviewing closing arguments in the Larry Whaley case out of Iowa. The jury remains in deliberations in this case. Brian Wagner, former prosecutor, current criminal defense attorney, remains with me here at the Law and Crime Network. We're having a good discussion going on here behind the scenes about exactly what the jury might be trying to pick through here, and I keep latching on to this whole notion that it is a reasonableness standard. Is it reasonable for somebody to open fire when they hear sounds outside their door, hear a key sliding into the latch? But you keep pointing out to me, and I had to go back and reread the statute again to make sure how the words were lined up, that it's reasonable under the circumstances. Yeah. So the jury's got to look at this sort of overall community standard of what we expect of one another as human beings who live in proximity to one another with what's going on in this particular case. And I think that you were articulating an argument very well. I don't agree with it, but you were articulating it well.
Yeah. And what it comes down to is it's not Joe Citizen, reasonable person. It's Joe Citizen under these circumstances. And these circumstances are Larry Whaley. Larry Whaley living with Miss Teeter, who has a boyfriend or an ex-roommate who's supposedly stalking her and seeking her out. It's Larry Whaley with all of his other issues, and some of them were not brought up during trial, but whether it's drugs or other people that are coming after him, there's a reason why he's living in the motel just that night. So it's all of those circumstances. When you're the defense attorney, you get up and you say, ladies and gentlemen, it's not you and I sitting behind that door in that motel room when we open fire. We're not the average gun owner. The person, the reasonableness standard that the judge is going to instruct you on after I finish, it's a reasonable person in these circumstances, knowing Mr. Whaley and all of his other issues surrounding him, is that person reasonable to believe that someone's coming through that door to kill him or Miss Teeter? And if that's the case, is he reasonable to open fire before that person even shows his or her face? And I submit to you, ladies and gentlemen, he is. But the argument goes even further if you're the defense attorney, and this is what we were talking about off camera. As the defense attorney, I don't have the burden to prove that. Ladies and gentlemen, the government, sitting right there, they have to disprove. They have to prove that my client did not act reasonably. That's hard. That's hard to prove. When you put the burden on the government, and that's exactly how I would say it. Ladies and gentlemen, the burden is on the government to prove that my client did not act reasonable under these circumstances, given all that we know about Mr. Whaley and his troubled past and his troubled issue that day. And then, what a jury does, I don't know. But that's a strong argument to the jury, and all you need is one. You need one person to just say, you know what, they didn't prove it beyond a reasonable doubt, and you have a hung jury.
Your prediction for this case is mistrial or based on a hung jury or acquittal?
Given New York and my practice being in New York, yes. Rural Iowa, that much I can't be sure about. But as a prosecutor, this case would scare me in Bronx and Brooklyn and New York County and Queens. But in Iowa, where it's a little more rural, I can't be sure of. But yes, I would predict a hung jury.
Well, you may be right. I don't see it. I think that they're going to latch onto that reasonableness standard, but that's just my guess. I've been wrong before. If I'm
you
wrong,
and me both.
Then you know what? Great. Then we can both be wrong. But well, one of us is going to be right because you predicted the opposite of me. But we'll wait and see. The jury remains in deliberations, and we heard the defense just start to articulate a very similar argument to yours, Brian. Let's listen to a little bit more of the defense closing argument. Again, this is the Larry Whaley case out of Iowa. We're waiting to see if we get a verdict today.
Background that led to that hole in that door. Mr. Whaley bought a gun. This gun here, State's Exhibit 4. And he didn't tell Deb Ewing that he was going to go kill somebody with it. He didn't say, I was going to go shoot a deer. He said, I got this gun to protect you. Protect me. I mean, bear in mind, they had known each other for a day. Who knows what they talked about? Who knows how in depth Larry went into his business with her. But we know what Larry knew when he had those bullets bought, when he gave Ms. Ewing the money to buy those bullets. Mr. Whaley hooked up with Ms. Teeter and Kayla Van Syke, and they ran around town. They were all there when the bullets were bought. Everybody there, Deb Ewing, Kayla Van Syke, and Samantha Teeter knew Larry had a gun. And they knew that bullets were bought for the gun because they were there. Mr. Van Syke told us that he had a weird feeling, an uneasy feeling, because he knew Larry had a gun. They went to a hotel, Mr. Whaley and Ms. Ewing. And Mr. Hammerhand said that the reason they went to that hotel was because Larry said to Ms. Ewing, I don't want to have to kill somebody tonight. Well, I don't know what you make of that statement. She met with the police twice. She didn't tell them. Then when she had her deposition taken 3-4 months later, she came up with that statement. Let's say he made it. Let's say he made it. Hey, Mike Adams, you want to go down to the bar and shoot pool with me tonight? No, there's a guy down there that's after me. I don't want to be down there. I don't want to have to fight him. I don't want something worse to happen. Larry Whaley was trying to avoid a problem. If that is in fact what he said, and if that is what motivated his actions, he was trying to stay away from his house because people knew where he lived. Nonetheless, Ms. Ewing wanted to go back to his house, so they went. When they got to his apartment, he gave a key to Caleb Van Syke. Caleb, Samantha, and Deb Ewing got out of the car and went up to the apartment. And by all accounts, they had to buzz the security door to get in. And Mr. Van Syke buzzed everybody till somebody got tired of hearing the buzzer and just let him in. And he got in. He then took the liberty of taking a piece of paper and disabling the security door. He tampered with the security door. This was not just Larry's security door. It was the security door for every other tenant in that apartment. Why? What gave Mr. Van Syke the liberty, the authorization to tamper with that door? Because he's an innovative guy, and it saved him a little bit of effort. Mr. Hammerhand told you that not even Mr. Whaley had a key to that, because when he showed up with the police that morning, he had to buzz to get in. So, at 3:43 in the morning of the next morning, if Caleb is coming back, what would Mr. Whaley expect that Caleb would do or Samantha would do if they were coming to his apartment? A lot of things, and we'll get to those. But one of the things he had a right to expect was they would buzz the security door, because he didn't give them a key to the security door, because he didn't have a key to the security door, because he didn't even have it to let the police in. So, when Mr. Van Syke and Samantha did not buzz the security door, Larry clearly didn't know that they were downstairs. When Mr. Van Syke told us the reason he disabled the door was he didn't want to make noise. I get that part. He disabled the door about 7, 8 o'clock at night. I guess it kind of, if he didn't want to make noise, it kind of implies that he was going to be coming and going and buzzing and whatnot and causing, I guess, getting people's attention to try to get back in the door. I guess it's something that needs to be reconciled by you folks. When Mr. Whaley came back from Walmart, he came into the house, he learned that Caleb and Samantha had left. One thing he didn't learn was that key that he gave Caleb so that Caleb could let himself, Samantha, and Ms. Ewing into the apartment was gone. Mr. Van Syke took the liberty of taking the key. Now, Mr. Whaley never authorized that. It's like he never authorized him to tamper with the security door. guess what gave Mr. Van Syke the idea that it was proper for him to take a key to Mr. Whaley's apartment when he left? I mean, what if Mr. Whaley and Ms. Ewing wanted to leave? Did they have an extra key? Caleb may or may not have known, but why did he think he was entitled to have a key? When Mr. Whaley got home, he was afraid, and he put knives he wedged knives in under the trim alongside the door, so that even if somebody did manipulate the lock, the knives would add a second defense. Or if somebody kicked the door, the knives would add a second defense. He was clearly scared. Why would he have done that? Why would he have put knives in the door if he wasn't afraid of something coming through that door? We know he was afraid because he bought a gun, and he bought bullets. He apparently didn't have a gun. You know, the evidence doesn't say that he ever had a gun. Maybe he did. Who knows? There was a holster found in his apartment. It didn't fit this gun here, states 4. But he bought a gun. He got bullets. If he already had a gun, he wouldn't have had to do that. Why all of a sudden did he do that if he wasn't afraid? Why did he lock himself inside his own apartment and make it very difficult for people to get into his own apartment if he was going to go looking for trouble? The evidence shows that Mr. Whaley called Caleb's phone or Samantha's phone. They shared a phone 3 times between midnight and the shooting at 3:43 in the morning. There's no evidence that Caleb or Samantha contacted Larry during that time. He was texting. There was like one text to Deb. Deb didn't know if she told Larry about it or not. So, we know Larry's concerned for his safety. At 3:43 or thereabouts, Samantha and Mr. Van Syke returned to the apartment. They knew that Larry had a gun and bullets. Caleb had a bad feeling. Remember he said that? I have a bad feeling because he's got a gun up there. And he took a knife from wherever he was, and he was going to slip the lock of the garage to get his bike out because he didn't want to go upstairs. Again, this case is not about bike stealing, but what gave Mr. Van Syke the idea that that was appropriate to break in to Mr. Whaley's garage, to slip the lock or whatever he was going to do? Well, he had a bad feeling. He didn't want to go upstairs. So he shined a light on the window, and he whistled because that's what he does. He went through this security door that had been disabled, sabotaged earlier by himself, and went up to the door. He had a cell phone with him.
That was some of the defense closing argument in the Larry Whaley case out of Iowa. We have a verdict in that case. The jury announced it had a verdict within the last couple of minutes. The defendant walked into the courtroom very shortly thereafter. This is a pretty quick verdict. They've been at it for a couple of hours, but it hasn't been very long. Brian Wagner, former prosecutor, current criminal defense attorney, remains alongside me here at Law and Crime. You were saying quick verdicts always make you nervous, no matter which side you're on, no matter what kind of case, no matter whether it's a lot of facts or whether it's a lot of tricky law that they have to straighten out.
Yeah, because what you ask the jury to do is take the case seriously and really discuss the facts. And when they're able to return a verdict within 3 hours, 2 hours, 4 hours, what that tells you is how much could they have really talked about these complicated legal issues? Because they are complicated. It's not, you and I are both well-educated people. We have completely different views on where we'd come down on this case. So it always gives me some nerves no matter what side I'm on.
When I sat on a jury, the hardest part for me was trying to match everything up in the jury room with what the judge said verbally. I think that some of the states that we see where the jurors actually get to physically bring the instructions back, I think that helps. The problem that I had was just trying to remember, wait a minute, he talked about this law, but what did he say again? And then we're going out asking for readbacks and all this other stuff. And even then, we were all confused. And if I went back and looked at the records of that case, I might even shock myself at this point as to where we were going with things. That was really hard for me. It was long before I went to law school, but I think back to that experience and say, wait a minute, why don't we give juries more written material for the jury room? Wouldn't it make the job a little bit easier? Some states do it, some states don't.
So in New York, they don't do it. And the reasoning in New York is that you don't want jurors to all of a sudden be interpreting statutes and going back and say, well, it says this, and there's not a comma. You don't want that.
Well, they do that anyway, though. They're trying to do it, but the struggle was lining up the ear to the eye. Wait a minute, how did the judge phrase that? We just listened to it in sort of a monotone rambling. What did he say? We were just struggling to remember what the law was, let alone interpret it.
And so some states that don't allow the instructions to go back are trying to encourage jurors to come back and ask the judge for clarification. And that's the policy behind it. Also, in terms of whether you're a defense attorney or a prosecutor, what you rely on are these jury notes. When the jury sends back a note saying, can you define justification, self-defense again, can you define this testimony, read this back? When those notes are following the summation that you gave, whether you're the defense or the prosecution, that's when you know they are listening to you, and that if they're following your notes, then they should find in your favor. And so that's always a good indicator. Here, I don't believe there were any jury notes, so both sides, I'm sure, are sitting on pins and needles.
Yeah, we're waiting to see exactly how long it's going to take everybody to file into court. We have both the defense, the defendant himself, and the prosecution present. It looks like a lot of people are coming into the courtroom waiting to see how long it takes the judge to get on the bench in this courtroom in northeastern Iowa in the Whaley case. Now, some of the best testimony in this case came on the first day. The boyfriend who was present when this victim, Samantha Teeter, was shot, testified that basically they were knocking on the door. He heard a sound that sounded like a couple of 2x4s slapping together. That's how he analogized the sound, and just basically said part of her face was gone. So, I mean, it was graphic testimony, but the key to understanding it isn't so much in the death, it's the specific chain of events that led up to it. The going up to the door. He said that they were trying to shine their lights into the defendant's house to sort of let him know that they were coming back to retrieve this bicycle. Apparently, that didn't provide any kind of warning, and even then, I would say that plays in the defendant's favor. It makes it sound even more suspicious. Why are people, if he even noticed it, why are people shining lights in my house at 3 o'clock in the morning?
And the devil's in the details, right? So the flashlights, as you said, help the defendant's case of saying that I thought this was a burglary, but the knocking on the door probably doesn't help the defense case. And so it really just comes down to what the jury finds was reasonable and whether or not Mr. Whaley believing this was a burglary was reasonable.
Yeah, I mean, that's the number one question right here, and we're going to have to wait and see in just a couple of minutes exactly where the jury comes out on this. I've got the word terrified written down in my notes here. When the defendant said that when he heard the noise, the sound of the key in the lock, he had no clue who it was, and he was, quote, terrified. That was his version of things. And again, this goes back into, is society going to look favorably on his terrification? Is that the noun version of that? Or are they going to look and say, hey, look, you had just given a key to the victim. And it come back to try to fair.
So the best argument that the defense is going to have to that point is when the police arrive Mr. Whaley's in basically a state of shock, and he's saying, I had to do it. I had to do it. And the reason, that's called an excited utterance. The reason excited utterance is allowed, even though it's hearsay, is because the person saying it doesn't have a chance to reflect on what just happened. They're under such a state of shock that it's believed that the statement would have to be honest because they're too. And so if that evidence comes in, or came in rather, then the defense is really going to say, look, from the minute the police arrived, he's claimed that this was in self-defense. He didn't have time to reflect on this after meeting with his attorneys 6 months down the road. From the get-go, it's been self-defense, and that's the compelling argument.
Yes. Now, one thing that I was seeking clarification on before I brought it up is whether or not the presence of drugs in this defendant's place came into this trial. They kept it out.
Yes.
But there's been a lot of speculation around this desk in the bushes as to whether or not that would have played into a mental state calculation for the defendant, or whether the jury would have just looked and said, okay, if you're tripping out on drugs, whatever they may or may not be, and then you pull the trigger, we're just not going to reward that. You're convicted. That was a tougher calculation, I suspect.
Yeah. You can't use your inebriation, your intoxication, as a defense. So the fact that I'm high and then I hear a knock and I act unreasonably, that's not a defense. But that I owed a drug dealer money.
We've got the judge taking the bench, so let's cut back to the Larry Whaley case in Iowa for the verdict.